The first case is State of Ohio versus Stephen L. Couch. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Can I approach? Thank you, Jan. And I would like to reserve the 5 minutes for rebuttal.
Thank you.
Okay, so that I didn't know about the victim with just the initials. So anyway, this is one of the cases that I really look at and say, why has this even come to this point with these people? Mr. Couch is the defendant in this matter. Can I say grandfather? Okay. The grandfather is the alleged victim, whom he lived with for years, had a wonderful relationship with, lived with him through the grandmother's passing, cared for them through that time, and continued to live with his grandfather and take care of him thereafter. At one point, the sister, which is Miss Garrett's, sees things a little bit out of place at the house, things that aren't the same, which would make sense, as at that point the grandfather had been diagnosed with dementia and Alzheimer's. So they put things out of place, they put things where they're not supposed to. So it caused her to go through with things, and she had called the police and had said that and forged a check of Mr. Of the grandfather's without his permission, and he was stealing. So Mr. Couch gets charged, gets no contact order with his grandfather, thrown out of his home, eventually evicted, as the sister, Miss Garrett's, continues to now take control of the grandfather's personal property and estate. During and prior to these proceedings, the grandfather was evaluated and determined that he was incompetent. Judge Dunn in the building signed an order that he was not competent to handle his affairs and appointed Miss Garrett's the guardian over Mr. Therefore, all could be, I have to apologize, I didn't know, and it just comes out. I'm trying to control myself on the names, I really am sorry. It's throwing me off, but anyway. All communications with law enforcement are through her. After all these years, he's got to be stealing, and here's this one check, and he needs to be prosecuted. And they evict the boy, and he removes, during long periods of time, tools and things like that may have belonged to both of them, one of them, Mr. Couch and the grandfather, or whether the grandfather had given it to Mr. Couch. So, long story short, the case proceeds to trial, and he's found not guilty of the one and only check of the $400, but that the property that had been removed during the eviction process, that he was guilty of theft of those things of the grandfather. And the first issue comes into play since everything and all communications with law enforcement were with the power of attorney, the granddaughter, was whether the grandfather should have even testified in trial to say, I think he took my check, I think he took my things. I just don't know how you get around the court order that he's incompetent. It's not, and as the case law.
But aren't those two different standards? I think competency in the probate court versus whether someone's competent to testify in a criminal case?
I believe that you're accurate in that, because the trial court can determine if the person has the ability to testify there, and they're looking at truthfulness and whether they understand the procedures and things like that. But I think what you gotta look at is the nature of the mental illness, because dementia and Alzheimer's people, they're sharp as a tack from things years ago. But what muddies the waters is recent events. And this is what we're asking this person to testify to, is recent events, that they may or may not have an accurate recollection of what may have occurred. Why is it so out of the realm that, and it was shown at trial, it was not out of the realm that check was written and authorized, because the grandfather and him, they were going to a funeral and they were in things, and he wrote the check, thank God for the eyewitness, and says, yeah, I was there, wrote the check.
Well, with regard to the check, wasn't there a not guilty on that?
Right, but it's an example of how there was the allegation, hey, grandfather did this, you don't recognize this check, I'm sure you don't recognize this check, right, he must have stole this check, he must have stole this money, just like he must have took your tools, of course he wasn't gonna give them back. I mean, isn't that the issue? Was there an intent to deprive? I mean, did this kid really have an intent to deprive the grandfather of anything, somebody he loved and worked with? And these were things that, this was their hobby, this was their life, was tools and mechanics and cars. You know, that's a love, something that, I mean, us as women, I mean, what do we care about tools, right? But with them, that was something that was coveted and cherished, and in the last 6 months, he could have said, hey, grandson, have this hammer, I want you to keep it. It's got his initials on it, you know, and that hammer might be worth $3, but it means more to him because it's from the grandfather.
Counsel, can I interrupt you? I
Yes.
apologize, but I have a couple questions. And
Yeah.
one is, did everybody stipulate to the probate court finding of incompetency?
Whether there was a stipulation, that's a good question.
How did the evidence come in that he's incompetent?
It wasn't, the exhibits were introduced, the
Okay.
order of competency from Judge Dunn as well.
Okay, and there was
as the
no
order.
objection to that?
Correct, they
Okay.
were admitted into evidence.
All right, that's the first thing. And I assumed that there was nothing said in front of the jury, or the jury wasn't instructed anything about his mental incompetency in probate court.
I believe because those exhibits were introduced, he was
So they went back to
here.
the jury?
I believe that the exhibits did go back.
So the jury was aware that he had already been declared incompetent?
Correct.
Oh, that surprises me. Okay, and then in getting to the evidence here, when you talk about intent to deprive, your client's response in regard to all this was, well, I was just trying to get all the tools that were mine too, and I'd go through them later. But they said, well, they did have the initials on them, so why couldn't he have just taken the ones that didn't have initials on them?
Well, some of them did, some of them didn't, some of them they shared together, some of them they bought together, some he gave them.
Right.
And sometimes it's sit down as, hey, Papa, remember we were at that swap meet?
Right.
You bought me this, oh, that's right, I did buy you that.
But couldn't they have separated out the ones with his initials on them?
Who would have separated it?
Well, he would have. It's the whole issue here is intent, right? And if he says the reason why I took them was because of the fact that I didn't know whose was whose, you could look at him and say, well, at least these aren't mine. I know that much.
Yeah, we're also arguing a timing issue. This is a kid that had
Say again?
a timing issue. This grandson had lived there for years, had stuff everywhere. He had sheriffs there, get the heck out, you know, ready to lock the doors. He's grabbing whatever he could scramble, thinking, I'm never being able to come back. And how would I rectify this? He was also under the impression, if you recall from the transcript, that they were still going in front of Judge McElvain in Wadsworth Municipal Court to resolve the property issues. And he told the police officers, I have a court date for that. You know, do you know what I'm saying? You're talking about a man with very little needs.
What about him lying about the storage unit?
I think he was being precautious. If you heard those phone conversations with that detective, I would have been leery too.
And is that in the record, those phone conversations?
They discussed them, yes, and I think they played them actually as well. They had played the, because the defendant didn't testify, they had played the telephone conversation he had with Detective Curtin. Yeah, it was very, he was getting charged no matter what. I mean, that was the thing. It wasn't, let's get to the bottom of it. This guy's elderly. This is a family issue. This is something that could be sit down and sorted out. You have court in Wadsworth. Several times Judge McElvain had indicated to the power of attorney, Ms. Garens, that listen, this is a civil matter. You guys, we can sort this out. And which was never done. The option was, as the grand, let's have him charged and with a crime that he didn't commit, and then let's deal with it later. And that was part of the manifest weight and sufficiency, that there's no indication that that they met that burden beyond a reasonable doubt, that he thieved and committed the theft offense against the grandfather to support those convictions. And the state of Ohio mentions in their brief, well, he had 3 weeks. You're talking about a kid that's got 3 kids, that he takes care of on the weekends, works a full-time job, barely making ends meet. I don't know, it takes hours to do things and to find time, and it's not, there wasn't the time there. It's a sad state of affairs with that.
Counsel, you're moving into your rebuttal time.
I am. I'm moving into it? Okay, I'm sorry. Thank you, Your Honors.
May it please the court, my name is Stephanie Zeranek, and I'm from the Medina County Prosecutor's Office representing the Appellee, the state of Ohio. Stephen Couch was convicted of stealing many tools, multiple large toolboxes, a tractor, household items, and more from the victim.
Counsel, I'm sorry, you only have 15 minutes, so can I start asking you some
Please
questions? Yes, I have. I guess my main question is in regard to the competency issue. Because we don't usually see that where somebody is declared incompetent and then they testify in a court case.
Right, Your Honor. In this case, there was the voir dire outside the presence of the jury. The trial court judge and assistant prosecutor and defense counsel were all able to question the victim to see what he remembered.
And he did answer at one point. He answered a question that was obviously not correct.
He did do that, Your Honor. Yes, that is true. However, he knew that he had been sworn to tell the truth, and I believe the assistant prosecutor said at the time if there was any, issues with a witness remembering one thing or another, they might never have a competent witness.
Well, but there's a difference in somebody knowing that they're telling the truth, or they think they're telling the truth, and their ability to actually know if they're telling the truth. And I think that's what the argument they're making here is, because his memory was so poor that he had to be put under guardianship for person and property, and wasn't even competent to do ordinary affairs, and now he's in a nursing home, right?
He is in a nursing, well, he was, I believe he's passed away.
Oh, I'm sorry to hear that. But at any rate, so he was in a nursing home, so the point is, isn't there, again, another difference? There's probably different, variants with all this, but in this case, wasn't there an issue with his being able to remember? So how do we know he was able to actually be able to tell the truth? It was only his faded memory. I know that's just a horrible question, but
That's all right. I would say to that he understood that being under oath meant that he was to tell the truth.
Right.
And I believe that he told the truth to the best of his ability. He did say that he was at the one hearing that he had not been at.
right.
However, he knew what telling the truth meant. I believe he told the truth to the best of his ability.
And is that the only thing we look at, though, is whether he knows what the truth is?
Well, there's also the idea that the trial court determines if the person is incapable of the duty of a witness to tell the truth. So there's the standard that if the person is, and I believe that this was brought up already, if the person is incompetent to handle their finances, they're not necessarily incompetent to testify in court. The trial court judge actually raised that point, speaking with counsel multiple times, because he had practiced probate law and had been a guardian. So he knew very well that just because somebody is not maybe competent to handle their own affairs, and the victim needed the guardianship of his granddaughter to be able to, live in a safe environment and everything.
Let me ask you this, was there, your opposing counsel has indicated that there were exhibits about his incompetency from probate court admitted into evidence that the jury saw.
I don't remember that, Your Honor.
Okay. Was there any cross-examination or anything that was read by the judge or anything in regard to an instruction in regard to his competency?
I don't believe there was.
Okay, so nobody is able to cross-examine him, or they just didn't?
Well, they did, he was cross-examined, I know that. They examined him both outside the presence of the jury, and then in the presence of the jury, they cross-examined him as well.
Mm-hmm. But you don't recall it coming up and saying, haven't you been declared incompetent by from the
I
probate court?
don't believe that came up in the transcript, Your
All right.
Honor, but I'm not entirely sure.
Obviously we'll find it either way, but I just wondered. Thank you.
No problem.
How intense was the voir dire by the judge prior to him giving testimony about his competency? Was it a few questions? What specifically did the judge ask in voir dire?
The judge asked if he knew what his birthday was, the day, month, and year. He asked if he knew why he was there. And the victim said, yes, I'm here to testify about my tools and other items that have gone missing. The victim was even able, during that voir dire, to state that he was missing a canister set from the victim, from his house, and he was able to say who gave it to him and when they gave it to him. The judge also asked if he knew what telling the truth meant, to which he responded, I've been telling the truth my whole life, so 80 years. And then he understood that being under oath meant that he was sworn to tell the truth.
Did she ask him about his memory about recent events? That sounds like all past.
No, I don't believe that there was any question about it.
There was one question about recent events, and he answered it incorrectly, right?
Yes, that is true, Your Honor, I apologize.
No, that's okay, I'm refreshing your recollection.
And counsel, I'm just a little confused about whether or not the jury was aware of the finding of incompetency in probate court.
I don't remember that they were, Your Honor, but obviously, my opposing counsel was there, she would remember much better than I would.
Okay, thank you.
There was also sufficient evidence to support the convictions of theft from a protected class. The jury heard testimony that the victim was 80 years old, so he was a member of a protected class. And in order to convict, the state had to show that Mr. Couch had permission and purpose to deprive the victim of property and knowingly exerted control over the property without the victim's
Counsel, let
consent.
me ask you this too, because, our Court of Appeals, we get everything that comes from every court in the district. And so I've had many probate cases, and there are many that are just like this, where somebody alleges that a family member took items from the estate or from, somebody that was put in a nursing home or something like that. And usually they're not criminal charges. Why is this not just a civil matter?
I think in this case, Your Honor, it's the sheer amount of belongings that were removed. There was, I believe the guardian said over 100 tools that she looked at had the victim's initials engraved into them. There were at least 2 large toolboxes, and all of that couldn't have been taken the day of the eviction. There's just no way that all of those items would have left the property on the day that Mr. Couch was being evicted.
If there was no testimony by the victim in this case, would the prosecutor's evidence still have been sufficient here? You talking about initials on tools?
I believe so, Your Honor, because there was also evidence from the granddaughter's testimony, the guardian. She was present for several of the same events that the victim had been present for, going to the storage unit, retrieving some of the belongings from the storage unit, being able to identify that those were part of her grandfather's property, that they had his name on them or his initials or some other mark.
Did the victim testify, though, that he had not given him permission to take the property?
Yes, he did, Your Honor.
Okay, so without that testimony, where does that leave you? Because this was a situation, wasn't it, where grandson lived with grandfather for several years, and even some evidence they took care of grandfather, and they worked on cars together, they enjoyed that together?
Yes, I'm sorry, I don't understand the question.
Well,
Please.
don't you have to have somebody say that they didn't have permission? Because you have to deprive the owner. So isn't that a defense, or, I mean, that's not really a defense, it's something that the prosecution has to prove, that they took it without consent.
Yes, it is, Your Honor, it is something that the prosecution has to prove, and I
Okay.
believe that there was enough proof
Okay.
even without the victim's testimony, although the victim did testify very clearly several times that he had not given permission. The manifest weight of the evidence was also in favor of Mr. Couch's convictions. The state presented evidence that he knowingly removed belongings from the property and stored them elsewhere. The friend's house, the ex-girlfriend's house, the ex-girlfriend's storage units. And some of the belongings were found at the impound lot. The detective had taken them there. Mr. Couch was the only person who had access to the house and the outbuildings after he changed the locks, which even his own father testified that he wasn't aware that Mr. Couch had changed the locks on the property.
Do you know if he changed the locks before grandfather left the premises? Was there
I
any
believe
testimony
it
about
was-
that?
I believe it was after he left the premises, Your Honor, but I can't say for sure.
So
whether
when
it was
grandfather
or
was no longer living there, that's when he changed the locks, is that?
not. I believe so.
Thank you.
I believe so. And as I said previously, the victim repeatedly testified that he did not give permission to, he had given Mr. Couch permission to use the tools, but he had not given them permission to take all the tools elsewhere to the point where 2 of the outbuildings were completely empty. Therefore, the jury did not lose its way in concluding that Couch stole from a person in a protected class. The trial court acted within its discretion in allowing the victim to testify. The state presented sufficient evidence for the convictions, and the convictions were not against the manifest weight of the evidence. Therefore, the state of Ohio would respectfully ask this court to affirm the judgment of the trial court. Thank you.
You have approximately 4.5 minutes for rebuttal.
Okay, I just kind of want to touch on some of the things that you guys had brought up. I mean, I disagree with the state of Ohio that they have nothing without Mr. Jones could say that the grandfather this or the grandfather that. But without him saying that Mr. Couch didn't have permission, they don't have the theft. And again, of course, someone 80 years old or whatever is going to say he understands the truth. But what is his truth? What does he know to be real? Regardless of whether he's sworn. And I think what Judge Carr brought up was a very good point, was that the one event that was recent that he was questioned on in the voir dire, he doesn't remember. You know, he says, oh yeah, I was there, but he wasn't there. Which shows that that's where your checkered memory comes into play.
What about the fact, though, that that the initials were on the tools?
Well, nobody disputed that there was, you're talking about big toolboxes with drawers with everything just all thrown inside. There's no issue with that.
Were there photographs admitted as evidence?
there was photographs, and they had, and what I wanted to bring up with the way of, there was no permission for anything to leave my land. These are farm people, these are country people. They brought in Mr. Steve Zabo, which unfortunately, God rest his soul, told both of them died after trial. Both the grandfather and Mr. Zabo passed away after trial. And he was not with it the day he testified. But he had things at his house that, you know how long the stuff had been there? Because they borrow and use, hey, bring that trailer, we're gonna do this. I mean, and things that are hard to identify, stuff that are built in the backyard. You didn't go to Cub Cadet and buy a trailer with a VIN number and a plate on it. You know, these are homemade, wooden, you know, things that they used out in the country and went back and forth on. So I think those are the things that you have to look at. And
did the jury hear about that? About these things not being something that you went to the store and bought?
Yes, because they were described. Do you know what I'm saying? But there was a confusion because there were several trailers on Mr. Zabo's property, you know, so that it's like, okay, whose is whose? Do you know what I'm saying? Type of a thing. I want to bring up, State of Ohio brings up to you the storage unit, which they were trying to take things that weren't theirs. Oh, that looks like that. Miss Garens doesn't know the tools. She didn't know what she's looking for. She's just trying to scoop up everything she can. There's a motive and a motivation here. This isn't some innocent granddaughter that showed up out of the blue, scoops up, comes up with one. And the thing is, you say, why was this charged in the first place? I think if it wasn't for the $400 check, I don't know that this would have been charged. They already got him out there saying, oh, he stole that check. Police are thinking, oh yeah, now he stole all the tools. When he gets evicted, put him somewhere he lives.
But counsel, the jury was able to discern that, right? Because they found him not guilty of that.
We were able to show more on the check with the witness, the memory of think back now to the funeral, think back you needed clothes, you know what I'm saying, you traveled to, oh, okay, do you know what I'm saying, and then that's how that softens the blow. Something that just had happened, they had already removed, he didn't want to be removed from his house. State of Ohio says, oh, they need to get him to a safe environment. There was nothing to show that or that the grandfather was not safe where he was. He hadn't fallen, he didn't break a hip, he wasn't left for dead in the driveway. Do you know what I'm saying? He was scooped up, did not want to leave his home, put an hour and a half away into a nursing home, and then told, oh my gosh, we evicted, Mr. Couch, and all your tools are gone. Oh, of course, yes, it's devastating. What do you think? He's not even there to put his fingers on it or touch or see or feel. Do you know what I mean? That's a lot of trauma. On top of the Alzheimer's, on top of the dementia that he's suffering from.
And you're out of time, so if you could wrap up in the next 10 seconds, that'd be
Well,
great.
bottom line, grandfather should have testified. Jury lost its way on manifest sufficiency. Should have been found not guilty on defective offenses. Thank you, Your Honors.
Thank you both for your presentations. This court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again.